Our facilitator today is Steve Riley. Most of you know Steve. He's coached attorneys for more than 20 years. His one-on-one coaching focuses on a limited number of top-producing attorneys committed to taking their practices to new levels of excellence, profit, and personal success. Steve also presents at group coaching workshops around the country for individual law firms, state bar associations, and other legal organizations. Steve has a way of getting attorneys to see where they might be stuck in running their practices and guiding them through a process of self-discovery to implement impactful, sustainable change. So Steve, I'm going to go ahead and turn the webinar over to you.
Thank you, Susan. So good afternoon or good morning, everyone, depending on where you're at in the world, I guess. And welcome to this Practice Growth Series. We have a fantastic one for you today. And we're going to squeeze a tremendous amount of information, strategy, and thinking into a very brief period of time. So I'm going to apologize in advance that we're just going to go to work very quickly. Today's call is about the PPP loan and really about how to maximize the forgiveness under the loan. And most of you were on Mitch Fogel's call, who's our very own community member who did a fantastic job when the PPP loan came out, and Mitch, as most of you know, is an expert in SBA loans. And one of the things he said on that webinar was, well, the real issue, the real rubber meets the road, will be the forgiveness process. And today we have a special treat for you. We have Kevin Cameron. Kevin's a CPA. He is very well known in the Florida market, well known in the Tampa Bay area. Predominantly works with lawyers, small business owners, and has been really doing a lot of education on how to maximize forgiveness through the PPP loan process. In particular, he has been selling a fantastic expense and loan calculator process, which we have, Kevin been kind enough to negotiate with us and agree to a blanket licensing with us, or a blanket purchase with us for all of our clients, especially those who are attending the program. So Kevin's going to walk through that a little bit, but I believe that Kevin has some training videos up on YouTube and a few other places like that you can get access to. So with that, Kevin, welcome to the webinar. Thank you for taking the time to be here. Thanks for your generosity, and thanks for your thinking, and really thanks for all that you do for lawyers out there. I know you work with a lot of law firms, and we're really grateful for your type of expertise and grateful for your type of work. So you're going to have a ton to cover today. Where would you like to start?
Yeah, we got a lot to cover. I'm gonna start at the beginning, but I'm gonna spend a very little bit of time there. The slide deck is pretty extensive, and I'm sure that Atticus can provide the slide deck as a handout to everybody. There's some good, useful information in there regarding the PPP loan program, both the obtaining of the loan and, of course, what we're going to talk about today, primarily the forgiveness of the loan.
Yes.
So I'm going to dive right into it, Steve, if that's all right with you.
That's perfect. Thank you, Kevin.
All right, perfect. So first thing I want to mention to everybody is that the PPP loan program is not over, in as much as some banks are still offering the loan. So if you were a business that did not obtain the loan, maybe you thought you didn't qualify, or you were kind of concerned of the necessity clause that was in the loan originally. It's still there, by the way. It hasn't changed. It's in the statute. But the SBA has softened the bite of that necessity clause a little bit by saying that if your loan is under $2 million, you have a safe harbor for meeting the necessity clause. It doesn't mean they can't come back and still review the loan application originally. So you do want to use some caution and document why you believe you might need the loan or do need the loan. I think back in March when the law was passed, and from March to the beginning of April when they started accepting applications, I think that at that point, all of us small business owners had a high degree of uncertainty about our future. Maybe some of us still have that higher level of concern, so it would be something to take a look at. It's important also to remember that whatever I talk about today is based on current guidance from the SBA, which really stopped on May 22nd for the most part in the interim final rules that were issued on that date. And that was a follow-up to the forgiveness application, which was published on May 15th. So I'll talk about that a little bit. We do know that the PPPFA, which is the Paycheck Protection Program Flexibility Act was signed by the president last Friday, and it changes up some of the rules again, and it muddies the waters, unfortunately, in as much as there's a lot more questions now than there were answers prior to the PPFA, particularly with respect to the 8 versus 24 week covered period, which I'll talk about in a little bit, and also with the 3 more FTE reduction exceptions that the law has provided us. So now we have a total of 7 potential exceptions to reducing our FTEs that won't count against us. And I'm going to stress in maximizing the loan forgiveness, this is by far going to be the most important thing to remember. Now, of course, the next few slides, I'm going to kind of blow through them pretty quickly because I want to focus mainly on the loan forgiveness process. We all know what the Paycheck Protection Program Loan is. It's a bank loan. It's not a loan from the SBA, and it was under their 7A program, which is established and been around for a really long time. Originally, the loan was supposed to be at a 0.5% interest, and the banks didn't like that for obvious reasons, and the SBA agreed to allow the interest rate to be 1%. And we do know that the PPP FA changed the term of the loan for any loans that are obtained after June 5th to a 5-year term loan versus a 2-year term loan. Not sure how the banks will react to that. And the SBA made it clear that it's only for newer loans, not the older ones. And I think that might have had a lot to do with the banks not wanting to commit to changing a loan document they've already signed and the borrower's already signed.
Yeah, so, from a legal counsel perspective, that would just have been a nightmare.
Oh, I'm sure Mitch would be having a meltdown with some of his clients on that one issue alone.
The volume that he does for his firm, that'd be a nightmare.
Yeah, indeed. So we'll talk about how that PPPFA affects all the borrowers, because it was essentially retroactive for some of the other provisions. So we'll definitely get into that. The next thing to talk about is kind of where we stand, and this is a little bit dated now because this is May 30th. These were the stats from the SBA on May 30th, and we know that at that time there was still close to $140 billion left in the funding for the second round of the PPP loan program. We all know now that the first round, the $350 million, went up in 13 days, which is just crazy, but there's just thousands and thousands of loans that were processed in that short period of time. We're at about 4.5 million loans right now. A lot of small lenders got involved in this, community banks and those types of facilities or businesses. It's interesting because in your industry, you guys fall into the professional and technical services industry, and that group as a whole represented about 13% of all the loans that were issued, which is the second largest recipient group. So attorneys did a good job. Most of my clients that are attorneys were really proactive. As a matter of fact, I had 3 loans approved on that Saturday after applications started being accepted. They were all with the Bank of Tampa here in Tampa, and they were all approved at about 5 p.m. with me going back and forth with the loan officer, literally providing information on the fly. So that was an interesting day, to say the least. We all know also, and Mitch is very aware of this, that the banks are getting some really rather large fees for doing these loans. So it is a good profit center for some of the banks. Although I think when the forgiveness process starts coming along, it'll be interesting to see how they handle that, because that could be a lot of work. The SBA did tell us in the interim final rules that the banks are only required to perform a minimal review of the forgiveness application and the underlying documentation. So the banks and lenders will have to decide what that minimal review really means. I'm not going to talk too much about who qualified for the loan, because we pretty much know that almost every single business in the country qualified just because of how the CARES Act was written. And that was one of my concerns. Was I let all my clients know when I read the CARES Act that essentially there was about 31 million small businesses in this country in 2019. And if they all applied for the loan, the average loan would have only been about $11,000. So you did have to kind of strike when the iron was hot until that round 2 came through. Then it made our lives a little bit easier. The program is still really a fluid process. And that's something I can't stress enough, because as the SBA became kind of the regulatory authority for issuing guidance on this, we've gotten some mixed information. The original CARES Act and the statute said such things as expenses or qualified expenses, and we'll get into those in a little bit, were to be incurred and paid within that 8-week covered period. Then the SBA kind of changed it a little bit and said incurred or paid. And then we got additional guidance on some items that now it makes it look like if it's paid, incurred and paid, or incurred during your covered period and paid by the next billing date or payroll date, if it's a payroll item, you can include it. So we've expanded the window. It's no longer an 8-week window or 24-week window. It could be 10, it could be 10 and a half. It just depends on when the expenses fall. And we thought that maybe that was a mistake, but if you look at the interim final rules, the SBA literally says in there that they understand this might increase the amount of expenses that can be counted as qualified expenses, particularly for the non-payroll costs. But they also mention they recognize that it allows that, and because of the original cap on the loan forgiveness being that you had to use at least 75% of the forgiven amount for payroll costs, they didn't care too much about letting you push some extra expenses, non-payroll expenses, into that covered period. I thought that was an interesting way of them kind of giving in and saying, we really don't care because we've limited it. Now we know that the Paycheck Protection Program Flexibility Act changes the 75% test to 60%. And it's really important to remember, neither the 75% test nor the 60% test are cliffs. If you don't exceed that percentage of the costs being spent on payroll costs, the loan will still be forgiven, it'll just be partially forgiven. And it's also really important, the way that the SBA calculated the amount is they take your payroll costs and they divide it by 0.6. It seems a little illogical, but if you follow through the math, it works. So for example, if I had a $100,000 loan, I need to have at least $60,000 of payroll costs in order for me to possibly achieve 100% loan forgiveness. So it's just their way of saying that if you take the payroll costs and divide it by 0.6, then the balance of the amount between that number and the 60,000 can be the amount I use on my non-payroll costs. So a lot of people have been confused on how that math works. We know that the loan forgiveness application that was published on May 15th is Form 3508. It's an 11-page form. It's fairly straightforward. It does have a little bit of conflicting advice in there, or guidance, if you will, that I'll get into a little bit as well. Some of it has yet to be cleared up by the SBA. We're expecting them to be coming out with a new forgiveness application soon. I've also heard from several banks that have told us that they're not accepting applications for the forgiveness until after July 1st. So that's an interesting twist, because the original guidance was that you were to file for your forgiveness immediately after your covered period. Well, a lot of people have passed their original 8-week period and they're calling their banks, and the banks are saying, hold off, wait until we get back in touch with you. We're not exactly sure how it's going to work yet, especially since we're getting a new forgiveness application. But what I would encourage you, and I'll get into it again later with the forgiveness application and maximizing the forgiveness amount, we're going to want to make sure that you're doing your homework now and you're not waiting till later. And I'll talk to you in a little bit about that. But once we see what...
Just a real quick question or clarification. So not all banks are doing that. Some banks are doing that. So if you're listening to Kevin, you want to confirm with your lender whether they're taking applications or not.
Yep.
Right, Kev? Okay, great. I want to make sure I'm clear on that.
I haven't heard from a single lender yet, Steve, that is accepting applications. It's been the opposite. I spoke to 3 yesterday. They're all local banks and fairly large, but local. And all of them have said no applications yet. So yeah, you definitely want to check with your your lender on what their specific rules are. I also believe that probably all the lenders are going to use some form of a portal for submitting the application. You're not going to physically carry a paper application into the bank with a stack of backup data. I think you're going to have to upload all that data in some type of form, PDF or otherwise. So having that data already stored in a folder that you can easily access and upload would be a great idea. I also would encourage everybody to put all of that back up in order. So it's payroll costs, then what falls into the payroll cost category, which I'll show you, the mortgage interest amounts that you're paying, the utilities, the rents, and so forth. So it's very organized. I'm kind of advising people that approach it like an IRS audit. Have your documents really in good order, cover page, backup for the totals, so the bank can tick and tie it real quick and get you off their list, because the sooner you're off their list, the sooner you get your loan forgiveness. So
yeah, that's great. I'm going to try and tell everybody, prove it or lose it. You got to prove it or lose it.
Prove it or lose it. And the other comment that I'm telling people is if in doubt, go ahead and pay the expense. So if you're not sure if it can be counted, you might as well just go ahead and pay it if you're going to pay it eventually anyhow. Put it on the application, because on the worst case scenario is that they tell you it doesn't qualify. So,
that's good advice.
Yeah, and I'll get into some of what those items are. So we'll just kind of take a look at that. The details on the loan forgiveness, I think it's real important for us to realize that it is the criteria, or the items that count are your payroll costs, and payroll costs is a fairly broad definition to include all compensation, wages, tips, commissions, bonuses, hazard pay, and then your group health insurance premiums that you pay on behalf of your employees. If you have employees that contribute towards their health insurance through, say, a payroll deduction, you don't count that amount. You only count what the employer pays, you as the employer pays for health insurance. The guidance so far has all been directed towards group health plans. If you pay somebody's health insurance for an individual policy, we're not sure that can be counted. In some circumstances, you're not even supposed to do that any longer, but until we know for sure, I would probably say don't count it unless it is part of a group health plan. The word group is actually in the statute. It does include retirement plan benefits that are paid by the borrower. And there's where a real big wrench got thrown into the conversation, because when the SBA indicated that you can include retirement plan contributions paid during your covered period, they didn't tell you for what period they had to be applicable to. So we have a lot of borrowers who still owe money for their 2019 retirement plan contributions. And from what we can tell and interpret from the guidance they provided us is, for right now, we think you count those. So that could be a bit of a windfall for companies that have large 401k, profit sharing plans, pension plans, even a defined benefit plan. So if you have a defined benefit plan that has a $200,000 or $300,000 retirement plan contribution for 2019, paying that within your 8-week period or your 24-week period might be something that you want to consider. And before I go any further,
that is massive for a lot of people that have that.
That could be. I kind of still feel like the SBA may change that if they, there's not a whole lot of anti-abuse provisions in the law yet as far as the expenses are concerned. So we'll have to see if they give us more guidance on that, or if at this point they're like, no, we're not, this is what we're sticking with, and you go with what you've got. The only difference now is the 8 and 24-week covered periods. And let me talk about that real quickly. So originally, the law said that we had to use this money in a very specific 8-week period, starting on the date our loan is funded and ending essentially 55 days later for a total of 56 calendar days. And at that time, we thought that meant you would have to prorate expenses and so forth. And Congress was getting not particularly the House, but really Congress was getting a lot of kickback from small businesses, restaurants, bars, dental offices, medical offices saying, hey, I got my loan, but I can't even reopen my business yet. I need more time to spend this money. So Congress acted, the House first acted very quickly, fairly quickly as they can, passing this law that extended it or made the 8-week period now a 24-week period. Now you can't go back and borrow more money. Remember, your loan was originally based on 2.5 times your average payroll cost, or 2.5 months of payroll cost for 2019, but now you're supposed to use this, or could use this, for a total of 24 weeks. Well, if your business is operating as normal, your 24-week period is going to be far greater than a 2.5-month period. And I'll get into why that makes such a big difference in the loan forgiveness in a little bit. But what the PPPFA does is it mentions 8 weeks is still an option, but 24 weeks is now the rule. But it didn't tell us if we can do anything in between. And I got to tell you, since this law is passed, I've probably fielded close to 100 inquiries as to, well, I couldn't use it all in 8 weeks, but I'm going to be able to use it all in 10 or 12 or 14. Can I just file for my forgiveness application after I hit my total? That's not written in the law. That's not in the statute. We'll have to see if the SBA somehow interprets the law to mean you have a 8 to 24 week range. But right now, I believe it's just 8 or 24 weeks. And that'll come into play significantly when we talk about the FTE reduction issue. So the other 3 expenses that they let us include was payments on mortgage, interest payments only on mortgage loans. They had to be in place before February 15th, 2020. You're allowed to use the money on other debt obligations, including interest payments, but they're not part of the forgiveness. So we've kind of like carved those out from the process, because it doesn't make sense to use that money for those expenses and not be able to include it in the forgiveness, although you could use it for that. It's a permitted expense. Rent obligations for leases entered into before February 15th, 2020 can be included. That does include related party leases, and I'll talk about that in a little bit. And then payments for utilities for services that were in place by February 15th. The SBA gave us some confusing advice there that I'll get into in a little bit as well. So, and with respect to wages and payroll costs, the one thing to remember is that the definition of wages has been broadened a little bit. If you're a restaurant and you have 20 servers that make base wage plus tips, even though the tips come from the customer, you're going to still be able to count their tips in their compensation total. We thought this was like a little loophole or a weird twist on the law, but it hasn't been changed. And of course, in you all's industry, you don't do any, there's not any employees that get tips, or at least shouldn't get tips that often, but that is something that was kind of a weird quirk. The other thing that the SBA allowed us to do is include bonuses and hazard pay. Now, you guys are all attorneys, and so I don't really need to tell you this, but I'm not real fond of the hazard pay. I don't recommend people pay their employees hazard pay, because that implies that you might have hazardous work conditions. So if you don't have good policies and procedures in place to address those potential work environment hazards, I wouldn't necessarily be giving people hazard pay. Somebody has told me, well, they're giving all their employees hazard pay during the 8-week period because they might expose themselves to coronavirus at work. And I said, well, then you better make sure that you're minimizing their potential exposure, or you could have a big lawsuit on your hands from an employee who got sick on the job because you didn't have those precautions in place. So I think you just have to be careful.
McDonald's got sued in Illinois, or is being sued in Illinois on that particular issue. So yeah, I think it's very interesting. You're kind of tipping your hand there.
Yeah, I think Amazon has got a lawsuit filed against them already for an employee that got sick on the job. So we'll see what happens. With the 24 weeks versus 8 weeks, we also know that wages were capped for any employee, not just an owner, not just a manager, but any employee. The wages for the 8-week period are capped at $15,385. And that number is nothing more than $100,000 divided by 52 weeks times 8 weeks. Because originally, if you all recall, the loan limited any individual's pay to no more than $100,000 in the loan application. So therefore, the forgiveness application won't allow you to count wages of more than $15,385 for any one individual. It doesn't mean you can't pay them more, but the limit is $15,385 for the 8-week period. Presumably, the wage limit will be the 46,154 for the 24-week period, but that's not in the statute, and the SBA hasn't ruled on that yet. So we're going to have to see how they handle that, because by default, if you go the 24-week period, you're going to have a much higher payroll cost to include in the forgiveness application, which could come to your benefit. The SBA did throw a little bit of a curve at us because they identified a class of employees called owner employees and said those owner employees' compensation can't exceed the lesser of 8/52 or the 15,385 of their 2019 compensation. So if you had a S corporation shareholder who drew a salary of less than $100,000 in 2019, their compensation cap for the forgiveness might be reduced below the 15,385. We're still waiting to see if the SBA kind of fixes that. That might have been a drafting error in the interim final rule. It's one single line in the interim final ruling that mentions owner employees, that they have this specific cap. And we thought initially that was only for like self-employed people, independent contractors, or a general partner, but the IFR specifically references those classes. So it makes me think that the owner employee is a third class, which is maybe the owner employee of an S Corp or a C Corporation. We're awaiting to see if we get some clarity on that. Group health insurance, I mentioned a few moments ago, is premiums paid pursuant to a group health plan. Group health plan does include self-insured policies. So if you are in a self-insurance program, the payments you make towards that, I believe, are contributions to a group health plan. If you make payments to a group dental, vision, hearing type plan, I think that qualifies because that falls under the IRS's definition of group health insurance and group benefits. So I think that's important to point out. Some people are forgetting about that. It does not include workers' comp insurance. That seems to have been a big question I get is, can I include my workers' comp insurance in my payroll cost total? And there's no specific guidance telling us we can include that. On retirement plans, I talked a moment ago with Steve about the fact that the 2019 retirement plan contributions that are paid within the covered period, right now we still think that they can be counted. I would probably tell you to include it, maybe as a separate line item on your expense listing, and knowing that we might have to take it off, but at least it's something that I think can be allowed right now. State and local payroll taxes that are assessed on the employer can be included in the payroll cost. That's primarily things like unemployment tax. You might pay a tax to your township or your local city for an employee tax. If it's not withheld from the employee's pay, but rather paid by the employer, then it's included. So that's something that will help us too. But keep in mind, everybody, and this has been something that's been a little bit some misunderstanding, the employer's FICA and Medicare taxes are not part of the payroll costs. The employees is, because we count gross pay. So gross pay obviously includes the FICA and Medicare taxes we deduct from our employees' pay. But nowhere are we allowed to include the employer's taxes that they match on the employee's pay in the payroll cost total. So I've seen a lot of people make that mistake already.
That's interesting. That's a nuance I would have missed.
The main reason for that, Steve, is because the CARES Act let employers take the option of deferring their FICA tax. So you don't have to pay the employer's share of the FICA tax right now, which is at 6.2%. You can actually defer that, and you can continue to defer it now until December 31st, 2020. And whatever you have accumulated in that deferral, let's say you accumulated $50,000 of employer FICA taxes for the rest of this year that you've decided to defer, you can elect to pay that over a 2-year period. The first payment is 50%. It's due at the end of 21. The second payment of 50% is due at the end of 2022. So some businesses that are really cash strapped right now are electing to defer that. I think it's a little bit of a dangerous idea to do because you're just kicking the can down the road, but it is interest-free financing if you choose to go that route.
That's kind of how I was interpreting interest-free financing on money you owe.
Exactly, exactly. Don't forget you owe it. That's for sure.
Yeah, don't forget you owe it. Don't be buying.
It'll sneak up on you. Business mortgage interest payments. There's been a little bit of misunderstanding here because some experts are advising that if you have a UCC filed, say for a equipment loan or something along those lines, that it would qualify because there is one line item in some SBA guidance that says business interest, not mortgage interest or business mortgage interest. I'm not sure I agree with that. I think that they put the word mortgage in the definition or in the header to clearly indicate that it's got to be a mortgage. Now, that doesn't mean it has to be a real estate loan. So if I've got a client that has a $2 million revolving line of credit, and the security for that revolving line of credit happens to be a second mortgage on their commercial building, I believe the interest payments on that revolving line of credit can be included because they fall under the definition of a mortgage interest payment. So we'll see if we get any more guidance on that one issue. We do know for sure it's the one area where the SBA has told us it's a no-no is we can't prepay interest. And the obvious reason there is we haven't technically incurred the expense yet because the interest hasn't been earned by the lender yet. So
that would make sense.
Interest.
That would make sense to me. I mean, otherwise you're just taking advantage of this really extraordinary law.
Correct, exactly. And this is, I mean, you got to think about it for a small business that got a 120. The average loan, by the way, is about $114,000. And so, you know, that's a lot of money for a small business to get to help them through this process. It's Senator Rubio in their hearing, I think that was yesterday or the day before, talked about that the PPP program alone is, I can't remember what percentage he said, but it's substantially larger than the entire New Deal that was rolled out by the Roosevelt administration during the Great Depression. So wow. It's the single largest funded program that I think the government's ever done for a small business. That's very interesting. Rent on leases that were in place before February 15th, 2020. The things to remember there are, I mentioned earlier, related party leases count if they, obviously the lease should be in writing. You guys are attorneys, you know that you should have your lease in writing with your related party or your related company. If you don't, you have a payment history, you've documented the rents, you're paying sales tax on the rents in a jurisdiction where rents are taxable for sales tax. If you're following all those rules, you probably can still include the rent, but I'd tell you to just get a lease in writing. I mean, it just makes more sense because a verbal or oral contract is harder to prove than a written contract. So keep that in mind. It does include rent and leases on all business property. So that's car leases, that's equipment leases, telephone system leases, any type of leases you have, they do count. Storage facilities and things of that nature. If you're paying for offsite document storage, I believe that might count because you're essentially paying rental for storing files and documents, whether they're paper or electronic. I think either one would probably count. So that's something to consider. If you do have a lease that with a related party and you've been charging below market rental rates, there's nothing that says you can't charge arm's length rental market rates to that related to your business. So maybe look at what the rents have been and see if it makes sense to adjust the rent during at least the covered period. I think that as long as it's arm's length and you're not tripling the rent or something ridiculous, I think that you'd be okay there. I don't think that would fall under any type of anti-abuse provision. Utilities kind of got us really confused because unfortunately the SBA, they defined utilities to mean payments for the distribution of electricity, gas, water, transportation, telephone, and internet access. And everybody got confused on two of those words. The first one is transportation. How is transportation a utility? And I think what they meant was if you incur a transportation cost in connection with a utility, so a natural gas delivery or the physical delivery of a utility, I think that's what they meant. I don't think they meant like your car expenses or truck expenses if you're a trucking company. But they haven't clarified that yet, which is kind of interesting. We do know, or we do believe, that gasoline for a company vehicle is included, because in the April 20th interim final ruling for sole proprietors, they specifically mention gasoline for your business vehicle. So we're kind of hanging our hat on that one line to think that gasoline for a vehicle, a business vehicle, do get counted. Again, we're a little bit in the dark there as far as that's concerned, but just make sure that you track all those expenses. Every little bit helps. We do know that, you know, some of the obvious ones like your utility, your landline, your electric utility, your landline, your cell phone, internet access do count. We don't believe that it includes any type of streaming services, including your like law research, I'm drawing a blank on some of the names that the
like
companies.
Westlaw.
Westlaw. Yeah, I don't think that counts because that's not a utility. That's a service, subscription service. So I'm going to get into the beginning of kind of like how we can maximize our forgiveness here and streamline this pretty quickly. The first thing that I can tell you is track those expenses. If you're in week 7 right now and you haven't kind of done any look back, get on your accountant, get on your bookkeeper, get to your books, start running some totals. Even if you're not 100% sure of what to count, still maybe gray in a few areas, count it, add it up, maybe have a column for ones you're certain about and ones that you're not 100% certain about. But let's look at where we're at, because what we want to do is we really want to make sure that we count all the expenses. And that's why we created an expense tracker as part of our workbook for calculating the loan forgiveness. If our expenses exceed the loan, naturally you would think, okay, I'm going to achieve 100% loan forgiveness, but you're not. We're going to get into there's a couple penalties for not meeting certain criteria that's in the statute. The first one is that if you lowered anybody's pay, their effective pay rate, by more than 25%, then you have a penalty, if you will, for that. And it's the penalties based on the excess over the 25% reduction. So Steve, let's say that I employ you and I pay you $50 an hour. And after this all hit, I couldn't pay you any longer and I needed to reduce your pay down to $20 an hour. So you've taken a 60% pay cut. I'm going to pay a penalty on the amount of pay I reduced your hourly effective rate by more than 25%. So in that case, it's 35% of the total. So if you didn't reduce anybody's pay rate, effective pay rate, by more than 25%, don't worry about it. It's not going to apply to you. And the FBA.
Stupid question, Kevin. Does that apply to the owner operator inside the firm? It
doesn't. It doesn't apply to the owner operator or to anyone that was making over $100,000.
Okay.
You could. So if you had an attorney that was making $200,000 in 2019, and you went to her and said, "Hey, I can't pay you that much right now. I have to change your base to 100." That's a 50% reduction, but there's no penalty for that because she was making over $100,000 last year. The penalty is going to be she's going to be really upset, but there's no penalty for the actual reduction. So that's important to remember too. It's a good question. So if you did, then you've got to calculate what the effective reduction is for that time period and that covered period, whether it's the 8 or 24 weeks. If you didn't, then just disregard this. So this is clearly Congress's way of saying, we don't really trust small businesses. They're going to bring back employees and they're going to cut their pay, and employees are not going to have a choice because they got to get a job. And we don't want the small businesses to take advantage of the employees. Ironically, we sent out a poll. We kept expanding the poll. The poll started with 200, and then it got expanded to almost 1,000 small businesses. And the percentage of businesses that reduced their employees' pay, any employees' pay, even one, by more than 25% was 2%. So
wow.
Small businesses aren't doing that. I don't think that was too much of an issue, but it is part of the CARES Act. The other part that will affect your loan forgiveness is this almost mysterious FTE calculation. FTE stands for full-time employee equivalent. And it says if I reduced my FTEs during my covered period and I don't restore them by the end of the covered period, then I might not get 100% loan forgiveness. So they gave us a couple base periods to look at in determining what they call it the FTE Reduction Quotient. And so let's say, again, I'm going to do a real simple math here for you. Let's say that in the covered period, my average FTE was 20 employees. And in the reference periods that I'm allowed to look at, and I'll tell you what those are in a minute, let's say that my the lowest reference FTE for me in the reference period is 30, then 20 divided by 30 is 2/3, and the most amount of the loan I can have forgiven is going to be 2/3 of my total costs. So again, they were trying to essentially penalize you for not bringing back employees. Remember, the CARES Act was written specifically to maintain payroll and retain employees. Now, with the FTE calculation, they've taken out a lot of the teeth in that, and we'll talk about that in a minute. But if you did reduce your employees after February 15th, between the period of February 15th and April 26th, April 26th was 30 days after the act was passed, you've got to restore your FTEs back to the February 15th date, or you don't meet what they call the rehire exception. If you meet the rehire exception, then you can still get 100% of the loan forgiven. But if you don't meet that safe harbor, and it's important to point out that you actually had to have reduced your employees, your FTE count during that period between February 15th and April 26th in order to even qualify for the rehire exception in the first place. But if you don't qualify for that, then you've got to go into looking at your FTEs for the reference periods. So in the reference periods that they gave us really 3, but for attorneys it's going to be mainly 2, I think. The first reference period is February 15th, 2019 to June 30th, 2019. The second reference period is January 1st, 2020 to February 29th, 2020. Those are date specific, and what it says is what were my average FTEs in that date range. So I would go back and I would calculate that. The third one is for seasonal businesses, and most attorneys don't operate a seasonal business, but I suppose if you did qualify, you would be able to look at that and determine what your seasonal count is. And under that, it gets even more complicated because a seasonal business can pick any 12-week period between May 1st, 2019 and September 15th, 2019. So can you just imagine how like a land care company or landscaping company, they're going to have to go through that period of time and find where they have the lowest number of FTEs maybe for that in that period of time. It might be a bit of a challenge, but that's a third one. Again, I don't think it really applies to you guys. Let's focus on the first 2 only. So you measure your FTEs for that period of time, and you compare that to what you're at during your 8-week covered period or 24-week covered period to determine that percentage. And like I said in the example that I gave you, it's 20 divided by 30, which meant 2/3. So that means that I take my total costs, my payroll costs, my mortgage interest, my rent, my utilities, and I subtract any pay reduction penalty I have. I come up with a net total, and I would multiply that times 2/3, 66% roughly. And that would be the maximum amount of loan I could have forgiven. It could still very well exceed the original loan you took, and you'd be okay. You'd still achieve essentially 100% loan forgiveness. And I believe that's what's going to probably happen to most businesses that go the 24-week route, because your payroll costs are going to be naturally higher in the 24-week period versus the 8-week period. I won't get into the definition of FTE too much, except that the SBA threw a curveball on us there, because back in 2010, they defined an FTE as 30 or more hours a week, and now it's 40 or more hours a week equals 1 FTE. A lot of businesses don't even have employees that work 40 or more hours a week anymore. So you might be in a situation where you have a lot of calculations to do. The SBA lets us use a simplified method that says I get to count a full-time employee who was full-time throughout that measurement period. I count them as a 1 FTE. And for an employee that worked part-time at any point in the reference period or the measured period, I can count them as a 0.5. So I worked with a small business, not so small actually, but a business in California that owns a lot of fast food restaurants, lots of them. And so what they did was, as they hired people back, they hired people prior to the COVID-19 outbreak. Their employees averaged just about 20 hours a week. Now they're hiring people back at about 12 hours a week. So even though the people were working 20 hours a week before are now working 12 hours a week, if they take the alternative measurement of 0.5 for a part-time person, that part-time person for 20 hours equals 0.5, and that part-time person working 12 hours a week equals a 0.5. So they meet that criteria. So one strategy for a business like that would be to employ more people on a part-time basis so they get more 0.5 FTEs. It's probably one of the first things they did to start taking the teeth out of this FTE computation.
Thank God there's people like you that enjoy math.
I'm not enjoying
Kevin,
the FTE calculation too much because they made it way too complicated, unfortunately.
Kevin, I do have to warn you. You have about 6 to 7 minutes.
Okay.
And then I've got 2 or 3 closing remarks.
I'm going to blow through the FTE exceptions. There are 7 of them now because the PPPFA gave us 3 more. The expense tracker, you can see a picture of it. I was going to bring it up on screen. I can do that real quick because I can just show you this is what it looks like right now, and it's a 16 tab Excel workbook that has both 8 weeks and 24 weeks built into it. So if you're going to go the 24-week route, you can put the data in. It gives you a real quick FTE application right here in this tab in both the 8-week and 24-week. These lines here match up perfectly to the existing SBA application and calculates the forgiveness for you. So I encourage you guys to use that. It's working out pretty well. The last few tabs here, Steve, this is where I'm going to blow through it real quick. Some of the ways you can maximize the loan forgiveness: maximize your payroll by paying bonuses, put family members on the payroll that are working in the business, consider paying your 2019 retirement plan contributions in the covered period, whether you go the 8-week or 24 weeks. Maximize your FTE reduction quotient by maybe adding more employees. Even family members do count. All people count, so keep that in mind. Increase your number of part-time employees if that helps. So that might be one of the ways to get around it. On mortgage interest payments, and this is really applicable to rent and mortgage interest. If any of you attorneys rent your office and you went to your landlord and asked for an abatement or a deferral during your covered period, you probably want to go back and pay that rent and maybe ask for a deferral or abatement later on, because the rent paid in the 8-week period or 24-week period can be counted. Rent paid outside of that cannot be counted. So I know that was an issue for a lot of small businesses. Also remember on your utility payments what is covered and not covered. I kind of already talked about that, but for the most part, just make sure that you do pick up the utility costs that your business does pay, particularly things like your cell phone bill. A lot of people have forgotten about the cell phone bill. Definitely track your expenses. My motto is what you can measure, you can manage. Steve, I probably have told Steve that 100 times in the last 30 years. If you can't achieve loan forgiveness in the 8-week period, then you've got to go to the 24-week period. Project out your expenses and see where you're going to be for the 24-week period. Watch your FTE reduction quotient, because if you have to let employees go further on down the road, your FTE quotient is going to go down, and you want to make sure that you still can achieve 100% loan forgiveness. If you can meet the loan forgiveness in 8 weeks, I really encourage you to do that for a couple reasons. First is get it out of the way. The second is we don't know if the SBA is going to keep changing the rules. And the third is that this comes with a whopping 6-year statute. And that statute kicks in 6 years after the later of the loan forgiveness or the loan payoff. So if you've got a new loan and you go out 5-year term on the balance of the loan, you're looking at a total of 11 years for potential look back by the SBA. I don't like that idea at all. That's it. So I can go over the spreadsheet if we got a few more minutes, or I can.
Yeah, tell you what, why don't you go over the spreadsheet?
Okay.
Take a couple minutes to go over the spreadsheet, and there's a couple things I want to update everybody that's attending on, so they know how to get any updates on the spreadsheet.
The first thing is that the spreadsheet has a landing page now. It's the first tab, and it's really basic information. It tells you to start with the 8-week if you're unsure where to start. We do have an instructional video on YouTube. It's a 60-minute video. There's a hyperlink built into the page there. I totally encourage you to watch that before you do anything else. It's not too bad. The original video was like 90 minutes, and we cut it down to 60 because we focus less on the law in the new video and more on the actual doing of the spreadsheet. So these are just hyperlinks to go within the workbook. But the first set of tabs, Steve, are the 8-week period. And the nice thing about these tabs is wherever there's an item where you need input data, the tab is light blue. My name is up here at the top. That all can be changed. You can modify the spreadsheet. You can put in your firm name if you're doing these for clients. You can give it to your bookkeeper to do it as well. Any place where there's a light blue colored tab, that's where data needs to be entered. The expense tracker was something we added early on. Originally, all we had was a forgiveness calculator and expense tracker. And what we've done is expand it now so that the forgiveness calculation is all done by formula and not manually. So you can list your expenses here. You can see here, I've put in a sample. And at the bottom here, if you've got any employees that made over the wage limit, which is $15,385 for the 8-week period, you plug that in there and you calculate that there. The rest of these tabs match up perfectly with the SBA's forgiveness application, super user-friendly. Anywhere where you see a light yellow cell, you can hover over that. It'll give you some direct information from the SBA or even some commentary from me. Again, these two schedules here are part of the application. Then you get to the actual forgiveness application. So you can see real quickly, in this case, this is sample company, and here's where their qualified expenses came in at. And they didn't hire back all their employees, so they had a 91% FTE reduction quotient. Their loan was 120,000. You can see in that circumstance, 91% of the qualified expenses was less than 120, and they had to pay back some of the loan. Then there are tabs we added more recently are to help people calculate all these different FTE calculations, which will definitely drive some of you bonkers. It's probably the hardest part of the loan forgiveness process. Mnuchin said the other day that small businesses can fill out their loan forgiveness application in 15 minutes. But I think what he forgot to mention is it's going to take you about 20 hours to gather the data before you actually fill out the application.
Yes, I'm like going, hey, Kevin, as we're starting to wind down, I just want to thank you on behalf of all the lawyers that attended the webinar that went to law school to avoid math.
Oh, sorry about that.
No. I just want to thank you because this spreadsheet and calculator is sheer genius. And if you're a bookkeeper, controller, CFO, or part-time team leader, you are going to make a huge difference with a lot of people with that. And I really, really want to thank you for really making a deal with us so we could provide this to our clients. So those of you that are attending, you can actually download this calculator directly out of the dashboard. And as you probably figured out that this thing will be updated constantly, and we're going to create a landing page on our website. You'll be able to download it for free with a code. So anytime there's an update, we'll let you know, and we'll control the quality of the, the version of the update from the download page from our website. And your RAs, your coaches, your practice advisors will let you know when there's one to download if you need this particular tool. Second, Kevin, you're also doing an email for people, a newsletter for people. How can they get on your newsletter?
Just send us their email address. They can email my assistant. Her email is hwisneski, WISNESKI, @clvalue.com. And we are manually sending out emails of general interest. And if there's any updates, we do a CARES Act update almost immediately after we get new guidance.
Now, we didn't have time for questions, but those of you that are on the call, to the extent that we can get Kevin questions, we'll do that. Well, my request is that you don't bombard Kevin with a bunch of free questions. He was kind enough to work a deal with us on the calculator. If you've got some issues that your CPA, your lender, your advisors can't handle, my request is to hire Kevin, not ask him for free stuff. Now, Kevin's one of the nicest people you're ever going to meet. He'll do stuff for free, and just as a favor for me, don't take advantage of him, because that's just not fair to him and not fair to his family and not fair to his clients. So if you need help, hire the man, and he'll be more than happy to help you, but you have to insist on hiring him, otherwise he'll try and do it for free. And then I can't think of anything else that I want to make sure I touched on other than making sure I said thank you, thank you, thank you, thank you. Great work, brilliant thinking, and I know you've been working endless hours during this process, and I know you're making a heck of a difference. So thanks for everything that you're doing, bud. Really, really appreciate it. Really do.
I appreciate that.
And then those of you that are attending, you heard just once again, is Heidi Wisniewski. Give her last name again, really slow for those of us who can't write fast.
Wisneski.
Okay. And so if you're not sure about that, you can also email Samantha, my assistant, Samantha L, at Atticus Vantage, and she'll make sure you get connected to Kevin's email list. So with that, Susan, I believe we're done for today. We're right at 1 o'clock exactly. I know Kevin's got a slam schedule. I got to teach a Dominate Your Market program in about 30 minutes, and everybody's got things to do. So those of you that did attend today's program, thanks for attending. I hope you found this very valuable. And if you've got any questions or issues, don't hesitate to reach out to your coach, your resource advisor, or you can always email us at grow@atticusadvantage.com. Susan, is there anything you need to say to wrap up? I don't know if you're still with us or not. I can't tell.
No, I'm still here. Kevin, thank you again for all the information you provided, and that worksheet is going to be a tremendous help to our clients.
It's incredible. It's incredible. Sheer genius. The work that you did there is just brilliant. It's going to save. There's some team leader right now or some bookkeeper right now sending you love virtually because you just made their life so much easier, buddy.
I hope so. I hope so.
All right. Thank you, everybody. Great job, Kevin. Once again, thank you. Talk to everybody later. Good job.